Welcome to the American Bar Association webinar, The Muslim Ban Revisited, Trump versus Hawaii 2 years later. My name is Engy, Abdelkader, and I'll be acting as the program's moderator today. Today's webinar is hosted by the Section of Civil Rights and Social Justice, and it's sponsored by the Rights of Immigrants Committee. It's part of a 6-part national lecture series with a new program on the third Wednesday of every month. This is our last event in that 6-part lecture series. We're excited to have a number of other important co-sponsors, including the ABA Commission on Immigration, the ABA Criminal Justice Section, the ABA Center for Public Interest Law, the ABA Section of International Law, the ABA Government and Public Section Lawyers Division, and the ABA Commission on Hispanic Legal Rights and Responsibilities. We appreciate all of your support. It's also important to highlight that none of this would be possible without the logistical support of ABA staff. Thank you specifically to Paula Shapiro and Ali Kilsgard for all of your work in making this program a success. We have an exciting lineup for you today, but first let me lay the substantive foundation for our discussion. As some of you are aware, Donald J. Trump's ascension to the White House is arguably the most consequential development for religious freedom and immigrant rights in contemporary America, particularly as it relates to Muslim Americans. The 2016 presidential election cycle exacerbated already worsening anti-Muslim sentiment across the country. Then Republican presidential candidate Trump specifically ran a campaign that exploited national divisions, animosities, and anxieties surrounding Islam and Muslims. Just a few months after declaring his candidacy during a September 2015 New Hampshire town hall meeting, one of Trump's supporters asked when the government would quote-unquote get rid of Muslims, while referencing imaginary training camps sprawled across the country. Rather than providing a corrective, Trump responded, "We're going to be looking at that and a lot of different things." In the days and weeks that followed, Trump publicly advocated for closing mosques. He also spoke in favor of special identification cards, warrantless searches, and a religious registry for Muslim Americans. On December 7th, 2015, Trump unveiled his infamous Muslim ban. After the tragic mass shooting by a Muslim couple in San Bernardino, California, Trump released a written campaign statement that called for a, quote, total and complete shutdown of Muslims entering the United States until our country's representatives can figure out what's going on. Later that same day on MSNBC, Trump explained how immigration officials would operationalize that measure. They would say, "Are you Muslim?" Trump was then asked, and if they said yes, they would not be allowed in the country. Trump replied, "That's correct." Soon thereafter, Trump likened his Muslim ban to former President Franklin D. Roosevelt's decision to intern Japanese Americans during the Second World War due to a perceived national security risk. Trump explained in relevant part, "This is a president highly respected by all. Roosevelt did the same thing." Indeed, 2 months after Japan attacked Pearl Harbor on February 19, 1942, President Roosevelt signed Executive Order 9066, forcing the relocation of more than 100,000 Japanese Americans into internment camps around the country. The Supreme Court upheld the order's constitutionality in Korematsu versus United States, holding that the government's internment of citizens was lawful during wartime to avoid espionage. Notably, this internment is widely regarded as one of the most appalling violations of civil liberties in American history. Once in the White House, President Trump has persisted in exploiting divisions around religion, race, and immigration status. He consistently labels Muslims in dehumanizing terms, specifically as disloyal, suspicious, and dangerous national security risks. 1 week following his inauguration on January 27, 2017, President Trump signed an executive order entitled Protecting the Nation from Foreign Terrorist Entry into the United States. The order, also known as the Muslim ban, explained that its objective was to protect Americans from immigrants who bear hostile attitudes towards the U.S. and the Constitution, and who also place violent ideologies over American law, as well as those who engage in acts of bigotry or hatred. To that end, it immediately barred entry of immigrants and refugees from 7 Muslim-majority countries: Iran, Iraq, Libya, Somalia, Sudan, Syria, and Yemen, for 90 days. The order applied to non-citizens with lawful permanent residence, as well as immigrants previously authorized to live and work in the country permanently. Those outside the U.S. at the time of its issuance were barred from re-entry. In addition, it prevented immigrants enrolled in universities or employed on temporary work visas from entering the U.S. if they arrived from one of the designated countries. The order also temporarily suspended the U.S. refugee admissions program in its entirety, preventing travel into the country and any decisions on refugee applications for a period of 120 days. Notably, the order repeatedly cited the 9/11 attacks in support of its purported objective in enhancing national security. Significantly, however, none of those hijackers came from the countries enumerated in the Muslim ban. According to research from the Cato Institute, not a single person from the designated countries has killed anyone in a terrorist attack on U.S. soil. Still, at the order's signing ceremony, President Trump explained that the measure was, quote, establishing a new vetting measure to keep Islamic radical terrorists out. The order avoided explicit references to Muslims so as to appear facially neutral with respect to religion. However, many pointed to President Trump's prior campaign promise to ban Muslim immigration as evidence of discriminatory intent. Ultimately, the ban faced numerous legal challenges to each of its three distinct iterations. On September 24, 2017, President Trump signed a third and final iteration of the original Muslim ban. Entitled Enhancing Vetting Capabilities and Processing for Detecting Attempted Entry into the United States by Terrorists or Other Public Safety Threats, that proclamation was more narrowly tailored than its predecessors. It explained that 7 countries did not meet a baseline for the kinds of information required from foreign governments to facilitate official vetting of immigrants and refugees. According to the criteria, which assessed identity, security, and public safety threats, as well as national security risks, 16 countries were initially categorized as quote-unquote inadequate, while 31 additional countries were found to be at risk of becoming inadequate. Although subsequent engagement period allowing countries additional time to meet the criteria yielded significant improvements, the Trump administration ultimately deemed 7 countries as inadequate and banned immigration from those countries. Unlike in prior versions of the Muslim ban, those banned countries, Chad, Iran, Libya, North Korea, Syria, Venezuela, and Yemen, did not exclusively consist of Muslim majority nations. However, the ban only applied to high-level officials for Venezuela, and only a few immigrants traveled to the US from North Korea. The list also included Somalia, even though the country met the baseline criteria, while omitting Iraq, which did not. As with the prior versions, foreign nationals from the Muslim majority countries were barred from traveling to the US, but this time indefinitely. Similarly, this executive order inspired a wave of lawsuits claiming violations of constitutional and statutory guarantees. Representative of these lawsuits is Hawaii versus Trump. On October 15, 2017, the state of Hawaii challenged the third iteration of the original Muslim ban on similar grounds as the first 2 orders. While the third ban included 8 countries, the state only challenged the restrictions against the nationals of the 6 Muslim majority countries. The government, on the other hand, argued for judicial deference in favor of presidential supremacy in matters of national security and foreign policy. It explained that the executive must be permitted to act quickly and flexibly in these areas. As such, the government cautioned the court against second-guessing the executive branch's national security judgments. Ultimately, a conservative majority on the US Supreme Court allowed the administration to proceed with that last iteration of the Muslim ban. With this backdrop in mind, this webinar is important for a number of reasons. The discriminatory laws, practices, and policies promised and delivered by President Trump have broader social, political, and economic ramifications. First, they reinforce misconceptions about Islam as an inherently violent religion. Second, they breed intolerance, fear, and hostility among the general population toward a marginalized minority faith community. Third, they signal government approval for discrimination against Muslims, citizens, and immigrants alike in education, employment, and the public square. Moreover, such institutionalized discrimination creates a precedent for the government to similarly mark other minority groups for official disfavor in the future. In fact, the most recent expansion of the ban to encompass primarily African nations proves this very point. Even more recently, with disparaging remarks regarding the coronavirus that's plagued us, connecting it to Asian American populations, we've also seen another minority group marked for disfavored treatment. However, President Trump does not enjoy unfettered authority even in the Oval Office. The separation of powers doctrine, US Constitution, and rule of law continue to serve as substantial checks in our federal system. Indeed, since Trump versus Hawaii, several important developments have occurred, from new legislation in Congress to class action lawsuits and more. As such, we're grateful to have a fantastic lineup of speakers to help us examine these developments. First, we're thrilled to be joined by Congresswoman Judy Chu. Judy Chu was elected to the U.S. House of Representatives in July of 2009. She represents the 27th Congressional District, which includes Pasadena, as well as San Gabriel Valley of Southern California. Rep. Chu currently serves as the powerful House Ways and Means Committee. The jurisdiction over legislation pertaining to taxes, revenue, Social Security, and Medicare. In that committee, Rep. Chu is a member of the Subcommittee on Health, giving her oversight over healthcare reform and crucial safety net programs, worker and family support, as well as oversight. She also serves on the House Small Business Committee, which has oversight of the Small Business Administration and is the chair of the Subcommittee on Investigations, Oversight, and Regulations. She was first elected to the Board of Education for the Garvey School District in 1985. From there, she was elected to the Monterey Park City Council, where she served as mayor 3 times. She then was elected to the State Assembly and then California's elected tax board, known as the State Board of Equalization. In 2009, she became the first Chinese American woman elected to Congress in history. On that note, please join me in welcoming Judy Chu.
Thank you so much. Thank you so much. And thanks to the Rights of Immigrants Committee of the American Bar Association for inviting me to speak on this webinar about the Muslim ban. I'm always proud to stand with the lawyers who are some of the most important fighters on the front lines in protecting our immigrant communities. Your work is especially critical as the Trump administration continues to test our laws and put forth policies that are inhumane and seek to separate families and children. The Muslim ban is no exception, and I'm committed to fighting back against it in its many iterations. Well, the failure of this ban was apparent the day that it began. I'll never forget that day in January 2017, just a little over 3 years ago, when Donald Trump shocked us with all the announcements of the first Muslim ban. What I remember is the chaos and separation of families with no justification. I was in fact on my way to speak at an event when I received a frantic call about 50 Muslims who were being detained at LAX for hours, despite the fact that they had a legal right to be in the United States. So I decided to drop everything and help in any way I could. I rushed over to LAX to advocate for the detained individuals. And in fact, I found out immediately that there were scores of people with a legal right to be here, kept for hours without food and blocked from receiving legal advice from an attorney. But what was even more impressive were the number of attorneys who came out, who dropped everything and decided to camp out at the airport for hours, offering their legal advice to anybody who needed it. I was so impressed by them, and that is why I am especially proud to be on this call, because I know what role you can take in making sure that there is justice with regard to this Muslim ban. This cruel ban continues to needlessly tear families apart and cause misery and psychological trauma. Spouses and fiancés are separated. Weddings, births, funerals, graduations have all been missed. Over 5,000 adopted children of U.S. citizens cannot join their families, and there's no end in sight. They're even looking to go further. In January of this year, the Trump administration announced that the ban would be expanded to include Nigeria, Eritrea, Kyrgyzstan, Sudan, Myanmar, and Tanzania. Unfortunately, the Supreme Court ruled in favor of the administration's third Muslim ban in Trump versus Hawaii. This ruling found that the president acted within his authority under Section 212F of the Immigration and Nationality Act, which allows him to suspend the entry of individuals if their admittance would be detrimental to the interests of the U.S. This ruling has only emboldened the administration to expand the ban. And that's why we have to fight back. It was almost exactly a year ago that I introduced H.R. 2214, the No Ban Act, in the House. And Senator Chris Coons introduced a companion version in the Senate. Our bill would repeal all versions of President Trump's Muslim ban, putting an immediate end to this family separation. It also requires transparency on how many individuals are granted waivers to the ban and are allowed to come to the US, so we know the truth about the actual impact of the ban. In addition, the bill amends Section 212F of the INA so that if a president does want to implement such a ban, they would actually have to produce specific and credible facts about the individual or class of individuals excluded from entering the US, and they would have to consult with Congress. The bill seeks to ensure that in the future, no one is excluded simply based on their religion or national origin. This is important for people like Ismail Al-Ghazali, who was my guest at the State of the Union this January. Despite being a US citizen, Ismail was separated from his wife. He didn't get to witness the birth of his daughter. He didn't even get to meet her for 7 months because of the Muslim ban. Luckily, he was able to appeal to Senator Chuck Schumer, who intervened for him, and ultimately, most recently, he was reunited. But there are many people like him who just want to be with their family members, who do not have a senator working on their behalf, and they deserve an immigration policy that is not arbitrary and cruel. That is what the No Ban Act will help us achieve. Well, I must tell you, the response to the No Ban Act has been tremendous. 218 members have co-sponsored the bill in the House, which is the threshold needed to pass a bill in the House, and there are 40 co-sponsors in the Senate. In addition, over 480 groups have endorsed it. But it still wasn't moving in Congress. Then in February, just a few weeks after the anniversary of the first Muslim ban, we were able to get movement to happen. The Judiciary Committee held a hearing and favorably voted to send the No Ban Act to the floor. Finally, after so many months and years of hard work to this terrible Muslim ban, a vote was scheduled for the floor. In fact, the bill was passed by the Rules Committee and was ready to be debated. The floor debate was ready to be debated. A vote date was even announced, but then COVID-19 hit within days. Suddenly, our nation was facing far-reaching stay-at-home orders, social distancing requirements, and an unprecedented public health crisis. Congress dropped everything we were doing and began working on these bipartisan relief efforts, like ensuring that workers had access to paid sick leave and that testing for coronavirus was free for everyone. Unfortunately, in all this activity, the No Ban Act was delayed. And actually, we haven't had a session on the floor with all of us there since then. And since we are in a new era where we are not supposed to be all on the floor at the same time without endangering ourselves in terms of coronavirus, it is unclear when we will actually have that type of session in the near future. So you can imagine our disappointment in getting so close to a floor vote and then having to shift gears because of the coronavirus. It even contributed to misinformation that our bill would have prevented travel bans meant to stop coronavirus, even though our bill specifically permitted the president to limit travel due to pandemics like coronavirus. Nonetheless, those on the other side of the aisle use this as their argument to oppose this. Although we are disappointed by the setback, we know the work is not over. The Muslim ban is just one example of the way this administration has weaponized xenophobia. Unfortunately, there are many others that demand action as well, because on the very first day of his campaign, President Trump has made it his priority to stoke xenophobia and direct anger at immigrants and communities of color. This has proven to be incredibly dangerous for immigrant communities, and as a result, hate crimes and violence have been on the rise since 2016. Unfortunately, the Trump administration has allowed its cruel anti-immigrant policies to hamper our nation's response to the coronavirus. And this xenophobia is particularly dangerous at this time, with so many immigrants and people of color on the front lines of our coronavirus response. In fact, there are over 2 million Asian American Pacific Islanders in the healthcare, transportation, and service industries. There are 27,000 dreamers working in healthcare. These are workers we're all counting on to risk their own safety in the most necessary places like hospitals and grocery stores. But the president's words have put these workers in danger. Looking to deflect anger about coronavirus away from himself, the president repeatedly used the term Chinese virus to refer to COVID-19, even though he was warned by health experts at the CDC and WHO not to associate the disease with a specific geographical location or ethnicity due to the stigma it causes. In this case, associating COVID-19 with an ethnicity has perpetuated false beliefs that people of Chinese or Asian ancestry are more likely to carry the disease. And as a result, we've seen an alarming rise of anti-Asian coronavirus xenophobia and discrimination in the past few months. In New York, there was a physical assault on a subway against a woman for wearing a face mask. And most recently, there was acid thrown on a woman who was simply emptying her garbage can, causing burns on her face and arms. In Texas, a man stabbed 3 Asian Americans, including 2 children under 6 years old, at a Sam's Club, saying that he wanted to kill Asian Americans. In the Bay Area, an elderly Asian man who was simply collecting cans was taunted and attacked by individuals who said that they hated Asians. And in Los Angeles, a 16-year-old boy was sent to the hospital after being attacked by bullies who accused him of having coronavirus just because he was Asian. At a time when many Americans are fearful and worried about their health and safety, it's more important now than ever to come together as a nation to get through these challenging times. And that's why the Congressional Asian Pacific American Caucus, which I chair, has called out President Trump and his followers every time they've used this term Chinese virus. We have been heartened, though, by the strong support we have received from our leaders in the Congressional Black, Hispanic, and Native American Caucus, as well as actually the entire Democratic Caucus and leadership, who stood in solidarity with us to denounce anti-Asian bigotry. In addition, we've led a resolution in Congress to address these anti-Asian sentiments pertaining to COVID-19, led by 2 of our KPAC members, Congressmember Grace Meng and Senator Kamala Harris, and it's received strong support in both chambers. So there have been many efforts to oppose this anti-Asian bigotry, but as a result, the president finally acknowledged how harmful his words could be to Asian Americans, but his words wouldn't have been necessary in the first place if he and Republican leaders had refrained from stoking xenophobia in this way. So we have to continue fighting against Trump's xenophobia and the cruel policies it inspires. And for that, I'm so grateful to have lawyers like you as allies. So thank you again for all that you are doing. And thank you for inviting me to join you today.
Thank you, Representative Chu. I know that I'm not alone when I say that we are inspired by your leadership and courage, and grateful for your efforts. At this time, I want to alert our audience that Representative Chu does have other pressing commitments to attend to. So we're going to open up the session to Q&A, specifically directed for the Congresswoman. So if you move your mouse at the bottom of the screen, you'll see that there is an icon titled Q&A, which is where you'd be able to type in any questions that you may have specifically for Representative Chu, as well as any other panelists during the rest of our webinar. But right now we're going to receive questions for Representative Chu before she departs the webinar. And as we start to review those questions, Rep. Chu, I do have a few queries for you. I know that you had mentioned the fact that the vote on a No Ban Act was delayed because of the coronavirus. And so related to that, is there any indication of when it may be up for another vote? In the meantime, what would you suggest constituencies or civil society members do to help support that initiative to see its realization? And additionally, I know that when the coronavirus emerged, that there were opponents to the bill who argued that the virus is in fact evidence as to why we should be barring various immigrant populations from the United States in the first instance. And so if you could address those questions quickly, and then I'll take a look at any questions we have from our audience.
Well, I want to tell you that the very last week in which we had the session, we were actually scheduled to have the Muslim ban on the floor. It was on the Friday of that week, and so we were truly anticipating it. But then the coronavirus broke, and we just had to address those issues. I do have to say that I talked to our majority leader, Steny Hoyer, who is in charge of scheduling these items on the floor, and he promised that this would be a high priority for when we get back. The only thing is we haven't gotten back. And in fact, with the terribly contagious nature of the coronavirus, we have to do our physical distancing. It's actually quite an endeavor to have us go back on our airplanes and come back. And then there's the issue of how we would exactly vote, since we're not supposed to be within 6 feet of each other. We have been pushing for some kind of remote voting system, but even to get a remote voting system, we would actually have to go back to vote on it. So we are at loggerheads right now. Our Rules Committee chair is looking at how we might accomplish that. So that is actually our first problem. I do know that our leadership is committed to having that floor vote. So that is not the problem. I do think that, however, the advocates out there still need to push this forward, to talk about the harm that it creates so many family members, so many people in this country, and that we need to have this vote ASAP. And let me tell you, the reason I know that this is very powerful is that you are the folks that actually created the breakthrough. Many members of the Muslim American community met with our leadership, and also met with members of Congress. And in fact, they met with members of Congress that are frontliners. We call them the ones who are in the red to blue states, and they were able to convince all of them that it was a matter of justice to be able to get this Muslim ban passed out of the floor. But you're right, the people on the other side of the aisle use the coronavirus to say that this is why we must have travel bans, even though the bill itself says that the president has the ability to have a travel ban if there's a pandemic. So they just didn't care what the truth was, and they just have gone ahead with that particular argument.
Thank you, Representative Chu. I do have a couple questions from members of our audience. One pertains to the current circumstances and context in which we find ourselves in, and whether the House of Representatives is considering doing business virtually or via telephonically. I think there's an analogy being drawn to the US Supreme Court, which conducted its first oral arguments via telephone for the first time in history because of the virus. And so there's an inquiry as to whether the House is considering similar plans. Another question is with respect to the likelihood of the passage of the No Ban Act, given the current constitution of the US Senate. And so if you could share your thoughts in response, that would be great.
Well, yes, thank you for the questions, because so many of our members would like to have remote voting, because there's so many logistics with all of us coming together from all across the nation, with all the flights that we would have to take, and all the problems that that would involve. So yes, we would like to do it. Like I said, it would have to involve changes of the rules and an actual vote for us in person first. Though, on the other hand, if you recall what happened in our last vote, we were able to have just a quorum of people voting, and that was enough to be able to satisfy the vote. We wouldn't want to do this every single time, but nonetheless, it was enough to pass that last vote, which was the CARES bill, which is the one that extended unemployment insurance and provided for this cash stimulus for everybody. So it was such an important vote. This issue is still rolling around. There's a lot of support for it amongst the members, and I truly hope we can do this, because I think that we are not going to be over this pandemic anytime soon. And what then also about the Senate? We have 40 members of the Senate that are co-sponsors, in fact, that are very enthusiastic co-sponsors. But as you know, we do not control the Senate. And in fact, Senator McConnell prides himself as being the graveyard for many of our House bills. We have over 400 bills that we sent over there that he's not taken up at all. So I do think that having this Muslim ban overturned depends on us taking back the Senate. And I do have high hopes for that, because I believe that there are certain states, it's actually a small number of states that we would have to turn over. We'd have to have a net 4 Senate seats that we would have to increase by in order to get this to happen. So if you see that there's some possibility for turning over some Senate seat, like in Colorado or Arizona, please get active, because that's really what we need in order to get this bill to ultimately make it to the end. Of course, we also need a president that will sign it into law, and that's where we also need to change who's in the White House.
Great. That's a really important point. I think oftentimes, particularly because of the particular juncture we find ourselves in, there's an outsized amount of attention being paid to the presidential election cycle, but the local elections are just as important. And looking at those congressional seats and who's actually working for our collective interests is significant. So that's a really important point. One more question from our audience is actually from a law professor. As I'm sure you're aware, Representative Chu, there's been much controversy regarding the recent public charge rule that has been instituted by the president and allowed to proceed, at least temporarily, by the US Supreme Court. Just this week, we actually saw a lawsuit in New York by New York State related to public charge, expressing concern about the immigrant populations who are afraid to receive health treatment in respect to coronavirus, because they're afraid it'll trigger the public charge exclusion. And so this particular audience member, as I mentioned, is a law professor, is asking whether Congress has considered including language in the CARE bill that would clarify that any health assistance would not trigger that public charge exclusion.
Thank you for that question, because the public charge rule by President Trump is one of the cruelest things that could have happened. It greatly expanded
the number of government programs that could deny a person a green card if they partook of that particular program. And it also caused great fear, because there are so many programs that people are truly qualified for, and yet they refrained from being in those programs or dropped out of those programs because they were afraid of being denied their green card. So yes, this is why I actually put forth the bill on no funding for the public charge rule. But we are in a critical situation right now with COVID-19, where people especially need to get their health care, and they especially need to get their testing. So yes, we have put forth the provision that there should be no counting towards the public charge during the time of this pandemic. And in fact, I have this bill, which I'm leading on the House side, and Senator Mazie Hirono is leading on the Senate side, which has to do with the way immigrants are treated under coronavirus, and the fact that we should use, for instance, for the cash assistance that everybody got, the tax identification number rather than Social Security numbers, so that those who paid taxes in the system can actually get some financial relief. That's one of many provisions, and the other provision is that the public charge rule should be not implemented in case of any program pertaining to recovering from coronavirus. So we are pushing for that. We are pushing for that very hard, so that everybody can get healthy and this nation can truly recover from this terrible pandemic.
Thank you, Rep. Chu. We're sensitive to the fact that you have a limited amount of time to share with us today. One more question. We appreciate the fact that you actually addressed the current context and the challenges and hostility facing the Asian American population today because of the irresponsible rhetoric of this administration. I, for one, and I know others, believe that there is in fact a relationship between the vitriol that our elected officials spew out, particularly about minority communities, and resulting discrimination as well as hate crimes towards those minority communities. And oftentimes ideologies of oppression such as anti-Asian racism, anti-Black racism, xenophobia, anti-Semitism, and Islamophobia overlap and intersect. And so while this webinar is about the Muslim ban and a No Ban Act, I think it is important that we discuss the current uptick in hate crimes confronting the Asian American community. And so along those lines, as lawyers, as allies, what can we do to support the Asian American community during this challenging time?
So we are really concerned about the hate crimes and hate incidents that are occurring against Asian Pacific Islanders. So there have been a number of nonprofit groups that have put together a hate crime reporting site. The most active one is under the title, if you put in Stop AAPI Hate, there is a way to report these hate crimes and incidents, and it's in different languages. So it has gotten, all the sites combined have found that there have been 1,600 hate crime incidents since this all started. And at its height, there were about 100 per day. So we do definitely need the legal community, because not all of those hate incidents rise to the level of a crime, but we certainly need advice for our AAPI residents, because some of them are absolutely scared to death, and they're even scared to even report, even though what they report on these hate incident sites is private and confidential. Nonetheless, we also want to have these hate crimes prosecuted, and these residents are definitely going to need help.
Wonderful. Well, thank you again. As I mentioned, we are inspired by your leadership and grateful for your efforts. So you do have friends here at the American Bar Association. So thank you for joining us. And we look forward to working with you again in the future.
Thank you.
Wonderful. So next in our panel is Professor Khaled Beydoun. And so allow me to introduce him. Professor Beydoun is an associate professor at the University of Arkansas School of Law and senior affiliated faculty at the University of California, Berkeley, Islamophobia Research and Documentation Project. He's a nationally recognized scholar examining national security and the First Amendment. His research examines the tension between First Amendment protections and prevailing counterterror policing programs. This scholarship has been featured in top law journals such as the Harvard Civil Rights and Civil Liberties Law Review and Northwestern University Law Review. His critically acclaimed book, American Islamophobia, Understanding the Roots and Rise of Fear, was published in 2018. And his co-edited volume, Islamophobia and a Law, was published last year in 2019. In addition to scholarly investigations, he contributes regularly to public intellectual discussion and the popular press, as well as a member of the U.S. Commission on Civil Rights in Michigan. Beydoun joined the University of Arkansas faculty in 2018 and he holds a BA, JD, and LLM. He is a native of Detroit, Michigan. Welcome, Khaled.
Yeah, thanks so much for having me, Engy, and thanks so much to the American Bar Association for hosting this important webinar. It's an interesting conversation to be having now with what's happening globally in this country with this pandemic. It really incites me to think about how this global pandemic might actually supplant or even reform how we think about the war on terror moving ahead. But those are questions we can field perhaps during the Q&A and the interactive component of the conversation. 4 things I'd like to do in my time is first give some historical context. We tend to think about the Muslim ban and Trump's Islamophobia as aberrational from American legal history, and specifically xenophobia that was seeded a long time ago. So just kind of contextualize where the Muslim ban comes from, this embedded sort of imagination and culture of xenophobia and what we now call Islamophobia, it being effectively a modern emanation of those 2 things. Next, I'll gloss over the decision made by the Supreme Court and kind of the touchstones of the Roberts majority opinion. Then I want to talk about how the Muslim ban is deployed beyond the immigration context, how the Muslim ban is actually deployed deep within the heart of Muslim communities as a counter-surveillance tool, and talk about how it functions in tandem with what I consider to be the most nefarious form of Islamophobia, or what I call structural Islamophobia, counter-radicalization policing. And then finally, I want to talk about how the Muslim ban also functions as a dialectical tool that actually emboldens structural Islamophobia abroad. In places like India, for instance, where we see a strongman populist like Modi employing the same kind of tactics as Trump. And then obviously in China, where Muslims in that country have been persecuted considerably, and we can see how the Muslim ban has provided the Chinese government with considerable momentum and weaponry to persecute Muslims in that country. Before we do that, what I'd like to do is define Islamophobia. The term is, thrown out a lot. It's obviously become a term of popular parlance and conversation today. And the Muslim ban, again, is a principal manifestation of what I call structural Islamophobia. A couple of years ago, I published an article in the Columbia Law Review where I took it upon myself to try to define what Islamophobia meant during a moment when the term was really emerging as a term that was being used popularly within the mainstream media. It was being adopted by activists and advocates, but it didn't have a cogent definition that I thought made sense of what was happening in the country, and specifically what Trump during that juncture was a candidate, was looking to deploy Islamophobia as a campaign strategy, but then obviously use it as a policy tool when he claimed the White House. I define Islamophobia as the presumption that Islam is inherently violent, alien, and inassimilable, driven by the belief that expressions of Muslim identity are correlated with a propensity for terrorism. That is the foundational definition, and there's 3 forms that emanate from that foundational definition. First, we have private Islamophobia, which is the animus that is inflicted by private citizens, hate mongers, and bigots. And this is the form of Islamophobia that the media tended to hone in on during the rise of Trump. Second, and I think most saliently, is that we have structural Islamophobia, which are the laws, the policies, the legislation, the Supreme Court decisions, the lower court decisions, which effectively affirm the idea that Muslim identity is conflated with terrorism, or this fear or presumption of terrorism that obviously drives the Muslim ban. And third, we have dialectical Islamophobia, which is this relationship, this communique between structural Islamophobia and the presumptions that Muslim is a national security threat, which drives the popular violence we see happening on the ground. So before I talk about the Muslim ban specifically and the decision that was rendered by the court in Trump versus Hawaii, let's lay the foundation that the ban was in no way something that arose from a historical vacuum. It comes from a deep-seated memory where this notion that Muslims are foreign and inassimilable was seated within the courts decades ago. Many of you might be familiar with a law that was enacted in 1790 called the Naturalization Act of 1790, which mandates whiteness as a prerequisite for naturalized citizenship. And this law functioned to effectively restrict the naturalization of Muslims as naturalized citizens up until 1944. There were a series of decisions which denied not only Muslims, but also Arab Christians who were presumed to be Muslim, undercover Muslims, from becoming naturalized citizens based on the idea that Muslim identity was racialized to be non-white. So it wasn't necessarily deemed to be, Islam wasn't only conceived of to be a religion that was distinct or antithetical to Christianity, it was actually racialized as a non-white religion. So when the 9/11 terror attacks happened and modern Islamophobia emerges, and Trump seizes upon this new these new redeployed tropes of Muslim otherness and Muslim threat, this emanates directly from this deep-seated, again, legal memory that Muslims were this fifth column, were this population that needed to be denied entry into the country because they threatened not only the security of the country, but also because they threaten the ideals of the country, the norms, the sort of democratic identity of the state. So when Trump announces that he wanted to put a temporary shutdown on Muslims coming into the country on December 7th, 2015, he didn't assume the task of having to persuade the polity and convince the electorate of a new form of foreign threat. This was something that the polity was already familiar with because of this long-standing backdrop of Islamophobia that had penetrated not only legal halls of power, but political halls of power, and obviously very saturated within the popular media space. We see that in films like American Sniper, for instance. We see it on television shows, and we clearly see it in the news media, both conservative and liberal. So Trump announces the Muslim ban, and I wrote an article in the Illinois Law Review, which effectively theorizes that he deployed the Muslim ban proposal as a campaign strategy to win over the electorate. And then he delivers his promise to the electorate a week after he's inaugurated with the first rendition of the executive order, which is comprised exclusively of Muslim majority states, the 7 states that were mentioned earlier. Executive Order 2 also comprised exclusively of Muslim majority states, with the lone difference with Executive Order number 2 compared to the first one was that Iraq was removed. So those 2 executive orders aligned with the rhetoric of Trump during his campaign when he was saying things like Islam hates us, Muslim immigrants are effectively undercover, ISIS members, and so on and so forth. Executive Orders 1 and 2 were essentially admissions of discrimination. They were admissions of explicit Islamophobia that the administration and the Trump administration feared would expose them to specifically establishment clause threat, the idea that this was facial discrimination that could undo the constitutionality of the order on grounds of it being in conflict with the Establishment Clause. Executive Order number 3, I think, is a concession on the part of the Trump administration to include 2 states, North Korea and Venezuela, again, which ate away at the superficial appearance of the executive orders as only being concerned with Muslims. And that was the decision that was rendered by the court, 5-4 split decision. In the majority opinion, Justice Roberts states that first, the president has the executive order power over immigration questions tied to national security. But again, in line with the strategic sort of revisions on the part of the administration, that the third version of the executive order was not facially discriminatory because it included 2 non-Muslim majority states And in addition to that, the rhetoric and the proclamations that were explicitly discriminatory made by Trump during the campaign and even while in office were essentially irrelevant to the assessment of its discriminatory nature in line with the First Amendment Establishment Clause. So the order was obviously upheld and then expanded, as mentioned earlier, recently, weeks ago, to include additional, some of them Muslim majority states, like Sudan obviously was included again, and then you had the inclusion of African states. So two things, and that's kind of the legal order of where we stand now. We have an expanded Muslim ban that was upheld by the court. Justice, again, Roberts delivered what is very much a textualist opinion that ignored the proclamations and rhetoric Trump made that were explicit in nature and explicitly discriminatory in nature. Two additional points I'd like to make. First is what we saw when the first order was signed was transformative in the sense, at least from my vantage point as a scholar who's examined Islamophobia and national security for a long time, is we see Islamophobia in the wake of the first Muslim ban being signed finally emerge into a centerpiece of the social justice movement. It was an issue that was championed by activists on the ground. It was an issue that was finally championed by mainstream legal organizations. It was an issue that obviously occupied considerable attention in the media space. I thought that to be very progressive, that non-Muslims and non-Muslim organizations were challenging not only the Muslim ban, but other forms of anti-Muslim policy in ways that they hadn't 15 years earlier after the 9/11 moment and after the establishment of the modern war on terror architecture. So that was positive, and we saw that in very lucid forms. Airports were being, became spaces of activism and protest. All sorts of challenges were arising in the Second, Fourth, and Ninth Circuits. So the Muslim ban, in some respects, galvanized a new moment of popular opposition to anti-Muslim animus, which clearly looms today. A point that I'd like to make that I write about in the book, and that Engy alluded to earlier, is I think that the advocacy response and the nature of the orders demonstrated how this country thought about Muslim identity in very monolithic terms. The injury that was unleashed as a consequence of the ban's enforcement had distinct effects depending on the identity of who the individual was. Let me read you a quote from a woman who was a PhD student at Stanford. Her name is Nisreen El-Amin, who identifies as a Black Muslim, which highlights the intersectional injury experienced by Black Muslims. And again, two of the 7 states that were initially impacted by the first order were majority Black African states. She says, "I think this order is a reflection of a larger trend in this country to criminalize Black people, to criminalize immigrants, and to criminalize Muslims. And as a Black Muslim immigrant, I'm really concerned about that. And I do think that the Somalis and Sudanese, people of African descent, who are going to be affected by this, I think they're going to be treated differently, frankly." So her quotes demonstrate how her injuries as a Black Muslim woman were distinct on grounds of both racial, religious, and obviously also gendered identity. In my remaining time, I want to talk about how the Muslim ban works in tandem, again, with what I consider to be the most nefarious form of structural Islamophobia, which is counter-radicalization policing. And to give a quick summary of what counter-radicalization policing is, it's a new surveillance model that was established in 2011 by the Obama administration, which essentially assigns FBI agents to work in tandem with local law enforcement. It's essentially a spying on Muslims program that is akin to COINTELPRO, which was used in the 50s and the 60s against groups like the Black Panthers, the Brown Berets, and so on and so forth. It capitalizes on Muslim informants to keep tabs on members of their community. As part of a racial justice fellowship with the Open Societies Foundations, I had a chance to interview and hold workshops in 40 mosques across the country. Many of them were CVE, Countering Violent Extremism, was taking place. And I learned firsthand how the Muslim ban was working in tandem with counter-radicalization policing or surveillance on Muslims, what FBI agents were doing were essentially looking to recruit informants from individuals from Muslim majority states. They'd hone in on individuals who were compromised in some way. So for instance, they might go to a mother's house who was concerned about a son who was an immigrant, who was outside of the country, and look to pressure her based on that circumstance to function as an informant. So you had those strategies going on deep within Muslim communities, and specifically Muslim communities that were populated by nationalities designated by the Muslim ban. So Hamtramck here in Michigan, which has a large Yemeni population, places like Minneapolis, which has a very large Somali population, became hubs where FBI agents and their informants and their proxies really used the Muslim ban as a tool to put pressure on individuals to work with the FBI to keep tabs on subjects, to keep tabs on institutions, to keep tabs on businesses that they suspected had terror ties, or individuals, young people that might become radicalized. So that's a dimension of the Muslim ban that, again, is not specifically administered or enforced just in airports or checkpoints, but something that's used deep within Muslim communities, which demonstrates that it has not only collateral effects, but very robust effects. Before I close, 2 quick points that I'd love to talk more about during the Q&A. I'm working on a book now examining global Islamophobia and learning about how Trump's rhetoric and Trump's policy is really emboldening foreign governments, people like Narendra Modi, who weeks ago passed what he dubbed to be his own Muslim ban, called the Citizenship Amendment Act, restricting immigrants from Muslim majority countries in India from becoming naturalized citizens. There's a clear connection there. And Modi and Trump are obviously close allies with what's happening in the United States. Is really encouraging foreign governments with kindred Islamophobic missions to do the same. And obviously in China, where we see very ominous forms of ethnic cleansing inflicted against Muslim communities in the form of concentration camps, again being encouraged by the momentum being spurred by the Muslim ban here in the United States, but the Trump administration's broader mission and mandate of Islamophobia. So I'll stop there, and I'm happy to have a more interactive conversation during the Q&A.
Wonderful. Thank you so much, Khaled, for that presentation. So next, we will turn to Elica, who joins us from California. She is the Pro Bono and Strategic Partners Director at the Lawyers Committee for Civil Rights in the San Francisco Bay Area, a civil rights organization focusing on immigrant justice, criminal justice, and economic justice, and marshals a private bar to help initiate structural change. She joined LCCR from Advancing Justice Asian Law Caucus, where she was the staff attorney and program manager of the National Security and Civil Rights Program. Her work focused on legal services, litigation, policy advocacy, and know your rights education, protecting the civil rights of Arab, Middle Eastern, Muslim, and South Asian communities, with a particular emphasis on the Muslim ban. She worked with a variety of law firms, attorneys, and law students on pro bono cases to advance the program's work. She's also the chapter president and former pro bono chair of the Iranian American Bar Association North California chapter. Elica formerly worked as a supervising attorney to establish the University of California Immigrant Legal Services Center, providing free immigration legal services, clinics, and know your rights training to UC students and their families across California. She was a project director of the One Nation Initiative at the California Community Foundation in Los Angeles, where she managed the first philanthropic program in Southern California for Arab, Middle Eastern, Muslim, and South Asian nonprofit organizations, advancing civic engagement, policy advocacy, litigation, capacity building. Elica received her BA from UC Irvine and Sciences in Paris. She received her JD from UC Davis School of Law, where she was an active member of the Immigration Law Clinic and a UC Human Rights Fellow at the Center for Constitutional Rights. She is a previous German Marshall Memorial Fellow and a 2018 recipient of the Minority Bar Coalition Unity Award. And I should mention that I know that the promotional materials had noted that we'd be joined by Shereen Sonora of Stanford University. Unfortunately, Shereen has been hospitalized. And so we are grateful that we were able to secure Elica to discuss some of the class action lawsuits that have been instituted since the Supreme Court's ruling in the Trump versus Hawaii. Also, as a reminder to our attendees, you are invited to pose your questions via the Q&A tab at the bottom of your screen. We will open up the session to a Q&A session as soon as Elica has completed her presentation. So welcome, Elica. We're very grateful to have you with us.
Thank you so much for having me. Thank you to the American Bar Association, Engy, and thank you, of course, to Congresswoman Chu and Professor Beydoun. It's really a pleasure to be speaking with you all. So I'm gonna shift to more of an experience of being a direct service attorney, being Iranian American myself, and part of the Iranian American Bar Association, and focusing on the impacts of the ban and the waiver provisions, and how it's been implemented and where we are now. I want to shift us back a bit to a bit of how the ban is working and the incredible amount of just pain and family separation that this policy is causing. So, you know, for individuals, whether you are a citizen or green card holder or applying for a tourist visa or student visas, there's of course different exceptions on the ban, but ultimately, you know, the ban policy states that you are not able to get a visa unless you qualify for a waiver. And it's really a policy, the way that I think many folks are looking at it, in addition to what's been outlined already on this webinar, in addition to the layers of Islamophobia, but also as a policy of family separation, that it's blocking life-saving access to medical treatments, preventing citizens and green card holders from being with their families, disrupting education, keeping folks from being together for weddings and for funerals, for different really important moments, and keeping folks in limbo for nothing more than religion and national origin. I also think that the family separation piece is key because to me, the Muslim ban is part and parcel of a broader attack on immigrants and communities of color. And so when we're talking about the Muslim ban, we have to remember that in 2017, when the first iteration of the ban came down, there were several other executive orders on border enforcement, enforcement of the interior. And so how does this tie in with broader family separation and attacks on immigrants and communities of color? So I was asked to focus on the waiver piece and how the Muslim ban is currently being implemented. And I think one really important context on how the ban is being implemented and where we're seeing this fight play out from a community perspective and a direct legal service perspective is that this iteration of the Muslim ban fight, I think, got kicked to the consulates with the third iteration. So I think everyone, you know, who's presented on the webinar and most people who are listening remember the airports and what happened in January 2017. And the reason that that fight was at the airports was because of how the first iteration of the ban was drafted and the fact that the law changed while folks were mid-flight. And so when they landed at different US airports, the law had changed. And so there was a lot of activism, lawsuits, and pressure for the airports. By the time we got to the third iteration of the ban in September, that fight had been largely kicked to the consulates because it prevented folks from even getting the visas in the first place. Now, the third version of the ban did have a provision called a waiver, right? Section 3C that said, otherwise banned individuals should be eligible to apply for a waiver. And if you fit those qualifications, you should be able to overcome otherwise being banned. And what the text of the third Muslim ban provided was that an applicant, right, the individual seeking the visa, would have to show that denying them would cause undue hardship, that the entry would not pose a threat to national security or the public safety to the United States, and that entry would be in the national interest of the United States. And the text of the third ban provides 9 examples where such a waiver might be appropriate. For example, if you are seeking to be reunited with a United States citizen family member, if your case involves a child, if you have previous ties to the United States, if you're coming for educational purposes. So if you needed particularly urgent medical care. So the law is supposed to have this process, this mechanism for otherwise banned families and individuals to be able to overcome and to obtain the visas needed to be with family and to come to the US. If folks remember, you know, this has been such a roller coaster of different cases and injunctions and orders, but, you know, before the Supreme Court issued their decision in June of 2018, in December of 2017, the Supreme Court had actually lifted the injunctions and allowed the law to go into effect. And that's where we started to see that this provision of the waiver process was really a sham, implemented haphazardly, was really arbitrary and capricious and quite devastating. So the first case example I want to give at that time was, you know, an individual from Iran who had had their interview at the consulate before the executive order went into effect, and now was required to be eligible for a visa, but never had a chance to prove that, right? Or another example is an individual or a client from Yemen who travels through a war-torn country to get to a country that has a US embassy processing cases from Yemen, to be unclear what happens with their waiver. The reason why I flag that is because there never has been, and there's not to this day, an application or a form that individuals can fill out to try to qualify and apply for the waiver. I think one case that really shook us to the core and shook many of our communities to the core was the case of Mahmoud Salem, who was a 31-year-old Yemeni American citizen who died by suicide when his wife and two eldest children were denied visas because of the ban, and the waiver process was opaque. And they had been living in Djibouti trying to figure out what was going on with the waiver and what that process was happened. And 5 days afterwards, his wife and eldest children were issued visas, but they were issued too late to attend the funeral. So I raise all of this because, you know, the impact that's being felt just about the ban generally, and then even on this waiver piece, for many advocates and lawyers, we felt that even though, you know, the waiver provision creates an additional barrier, that the government should still be held accountable for having some type of a process, some type of waiver process, which many other immigration applications have. So in that vein, after the Supreme Court decision in June 2018, which, by the way, relied on there being a waiver process, Justice Breyer's dissent relied on, you know, and discussed the challenges with the waiver process. After the Supreme Court decision, the Parse Equality Center, which is the lawsuit that I support with, and another lawsuit, Imami versus Nielsen, were filed to hold the government accountable for waivers. I would also flag that, you know, for a long time, we didn't have any statistics on the waiver grants. When we filed the lawsuit, the percentages of waivers that were being granted, this was in 2018, were 2%. So that meant 98% of applicants were being denied. So the waiver process was really just a complete barrier in that respect. And so there was a lot of policy efforts also, in addition to the litigation, to require the government to provide ongoing reporting to Congress on the statistics and the waiver components. Currently, as of the most recent government reporting in 2018, they're stating that 35% of the waivers are being granted, but that's still a 65% denial rate, right? And we're talking about cases of families, citizens, folks coming to study, et cetera. The litigations for the waiver process are still continuing and are in this discovery phase. It's been incredibly hard with COVID and incredibly hard with the government kind of dragging their feet in that respect. But again, just the context of going from 2% to 35%, we still have a real uphill struggle in that respect. I think that while the waivers and accountability on the waivers is incredibly important and critical to families and to our communities, ultimately, you know, I think what Representative Judy Chu and Professor Beydoun were touching upon is that we need a much broader solution and a broader advocacy strategy than just the waiver piece. And so that's why efforts like the No Ban Act, policy efforts, broader work on racial profiling, national origin discrimination, work to fight Islamophobia are so key. One component of the No Ban Act that I wanted to layer on top of Representative Chu's comments is that policy, the No Ban Act, does have a validity clause where if passed, it would repeal, right, or invalidate not just the Muslim ban, but also the asylum ban and the refugee ban. And I think this is such an important point to hit on, that the Muslim ban, again, is part of many bans that target immigrants and refugees. And the last comment I'll make before we switch to Q&A that I was asked to touch upon is how a lot of the fight around the waiver or even advocacy against what's happening, you know, to me is, of course, most important to be centered by impacted communities and leaders who are feeling this the most. And in addition to that, really bringing that together with amazing law institutions, right? Law schools, like folks like, you know, Professor Beydoun, and also Penn State Law, UC Davis Law, a lot of other law clinics that stepped up around amicus brief filings, lawsuit filings, providing resources to the community, and co-counsel, major law firms that stepped in. Our co-counsel is Arnold and Porter and Lane Powell that really make the litigations possible. So thinking about ways in which we harness the broader power of pro bono and legal services and legal work, but to do it in a way that backs up what impacted communities, organizers, and people who are on the front lines need the most. And so that's what we've been trying to do with the Parse Equality Center waiver litigation. I'll go ahead and stop there since, you know, we want to leave time for Q&A, and happy to answer any questions.
Great, thank you so much, Elica, that was wonderful. So at this point, we will open a session up for Q&A. As a reminder, if you move your mouse at the bottom of your screen, you'll see that there is a Q&A icon that you can double click on and just type in your questions for our panelists, and I'm sure they'll be happy to field them. So Khaled, let's begin with you. You know, we know that recently, I believe in just a month ago, we saw the expansion of the so-called ban or Muslim ban to include primarily African nations. How does that impact the various theories that you've put forth in your law review articles examining the Muslim ban?
Yeah.
During your presentation, you actually mentioned the intersectional identity of victims of the ban and their experiences because of the discriminatory provisions of the ban. But this is intersectionality in a different light, right? We're talking about the intersectionality of ideologies of oppression, which I personally subscribe to. I think that ideologies of oppression such as anti-Black racism, anti-Semitism, Islamophobia, and xenophobia do intersect and overlap. And I think this is one exemplification of that. So if maybe you could speak a bit more to the recent expansion, and the fact that it's not just exclusively Muslim countries, but we also see the targeting of African countries and what the implications are in terms of policy going forward.
Yeah, you had the addition of 5 African states and also 2 Asian states, Tanzania and Kyrgyzstan as well. I think that, so Trump uses the Muslim ban and the expanded Muslim ban as a way to effectively, you know, satiate the hatred of his following. You know, it's no surprise that he expanded the ban as the presidential elections were revving up. The sad reality is this: I think that for the vast majority of his base, but also the vast majority of the country at large, they can't distinguish between Muslim majority countries and non-Muslim majority countries, whether in the Middle East, Asia, or in Africa. So when the archetypal Trump supporter sees Myanmar or sees Tanzania, they think foreign, they think Asian African, and then they think it potentially could be Muslim. So Trump is capitalizing on a popular ignorance of who Muslims are and which countries count as Muslim majority states in doing that. But I think that beyond just sort of the optics and the way in which Trump deploys the expanded ban as a way to deliver to his base during the presidential election is also the idea that we see Islamophobia obviously being an emanation of distinct forms of hatred and bigotry. It's not distinct. It doesn't function along a singular track. It converges with xenophobia at large, like you mentioned and Representative Chu mentioned earlier. It intersects with anti-Black racism. So the expanded ban is going to have a distinct form of injury and a compounded form of injury for individuals, for instance, who are Nigerian and Muslim. So let's say, for instance, you come from a Hausa Muslim family in northern Nigeria. You are going to be injured as a consequence of this expanded ban on grounds of your racial identity, but also your religious identity. So it manifests a broader form of bigotry and racism by the Trump administration in those two ways.
Okay, thank you. And then I know that when you first began your presentation, you mentioned the intersection of counterterrorism and particularly this pandemic and what counterterrorism policy may look like in the months and years ahead. I wanted to give you an opportunity to elaborate on that.
Yeah, I'm still kind of like thinking about that and contemplating what the war on terror is going to look like. There was an article in the Atlantic that was really interesting a couple of days ago written by Ben Rhodes, which was titled "The End of the 9/11 Era." And Ben Rhodes was a former national security aide for the Obama administration. Part of me would like to think that this new pandemic moment, initiates a war on pandemics that could supplant or severely diminish the war on terror. But I'm not convinced. I mean, I think what I see moving ahead perhaps is more pessimistic in nature. I think we're going to see the war on terror continued and protracted, but also tied to this new war on pandemics, which, like you've mentioned earlier and Representative Chu mentioned earlier, is going to hone in and fixate on Chinese and Asian identity as being the new pariah. So I see a continuation of the war on terror in conjunction with this new war on global pandemics that I think is going to inflict considerable injury not only on Muslims, but specifically on Asians and Chinese individuals.
Thank you. Elica, I wanted to turn back to you. We do have a question from the audience member, specifically regarding you had cited to 35% of waiver applications have been granted. And I think there's a request in terms of the source for that information, whether or not it's a government source or civil society sector.
Sure. So, I mean, that's the government's own reporting. It's available on the Department of State website. I'm happy to drop it in the chat box if folks can see that. But I think, even with those numbers, people are held in limbo. It's still not robust enough of a number. We started from 2% up to 35. And we only have those numbers because of advocacy to push the Department of State to publish them in the first place.
Another question for you, Elica. Is the waiver process identical for each of the impacted countries that have been identified by the ban?
That's a great question. So on the text of the ban, yes, but part of why we felt like this lawsuit is very important is the experience of different individuals and families across the consulate completely varied. So because there's no application, because there's no form that folks can fill out, and because it's been such a haphazard and chaotic experience, one embassy might accept documentation. Another embassy was not accepting any additional documentation. I mean, to try to be individual and navigate that process is a nightmare, let alone to try to be a lawyer to advise folks on what they should do. Was a nightmare and continues to be so. So technically it's the same criteria, it's the same law, but the experience across the embassies that we've seen and what we put in the lawsuit is that there's quite a variance of in that respect.
And also for you, Elica, is there any empirical analysis available in terms of the likelihood of success of those waiver applications with respect to the country of origin? So is it more likely that an individual applying for a waiver from country X is going to have a better experience than an individual applying for a waiver who's from country Y?
No, and I would even say part of why we brought the suit and part of what was so difficult was even two individuals in very similar positions, so same country of origin, both families were applying for an immigrant visas, were often being treated differently at different consulates or within the same consulate. And so, you know, our basis there was just that there really was a need for accountability because even within cases that you would imagine would be able to be processed in a similar way, we were not seeing that happen in the field.
Great. Also, Elica, could you discuss a little bit more the significance of pro bono counsel? I know that you sort of highlighted the fact that there are several big law firms which have been powerful allies and partners in this fight. But maybe just discussing to everyone who's on this call the significance of pro bono services and maybe drawing on these specific cases to help make your case in terms of why this makes a difference.
Sure. So I think, whether that was attorneys showing up at the airport and helping secure the release of individuals, whether that is know your rights presentations, direct representation, a lot of immigration attorneys that might not have worked on national security issues before, but then got trained. We did, I think after the Supreme Court decision, the Asian Law Caucasian partners, we trained, I think 500 lawyers on how to do Muslim ban cases in just a few months. And so I think the need for legal representation is strong. And the way that the different law firms stepped in to support with litigation is really key. That being said, I would also say that the ban is a great example of where the law just falls short, right? And where the Supreme Court decision was just devastating. And so thinking about how do we advance cases moving forward in a way that doesn't just put all our eggs in the litigation basket, right? And addressing issues around structural Islamophobia, how this ties to other pieces, around immigration matters, just that we need to focus on community building power, narratives, and organizing equally, if not more, than the legal strategies in certain cases.
Okay, and so it's, we've reached an hour, it's 4 o'clock. So as we wind down, I do want to give each of you an opportunity to share any thoughts with members of our audience. And specifically, oftentimes when we have these sorts of discussions, members of impacted communities may feel overwhelmed or a sense of helplessness in terms of, what can I do to make things better? And so perhaps if you have any, that might be helpful. So let's start with you, Elica. Sorry.
Sure. In terms of just what people can do to support fighting against the Muslim ban.
Also members of these impacted communities, right? So whether it's members of the African immigrant community, members of the Muslim American community, so on and so forth. So I think there's, a role that allies can play, which I think is highlighted by virtue of the fact that these advocacy efforts at the airport, although admittedly they also petered out with each successive iteration of the Muslim ban, the changing and the watered down versions of the language, making it less directed towards Muslim populations and converting it into a so-called travel ban. We saw less and less resistance, right? Mm-hmm. And at this point, there's now a controversy about whether or not we should call this initiative a Muslim ban or even a travel ban. I think many journalists have now routinely have adopted the language of a travel ban without the quotation marks, right? And I think that is significant and revealing in many respects. And so I think it's telling that yes, I think the advocacy efforts and the resistance that we first saw upon the implementation of the Muslim ban back in January of 2017 should be applauded, but also we should be fully cognizant of the fact that that is no longer the case. And in many ways, there's sort of a complacency that has settled over us as a population. And again, a sense of overwhelming and helplessness, even within these particular impacted communities. And so I think any inspiration or insight or observations you could share would be helpful.
Sure. I mean, I think, you know, each impacted community speaks for themselves and leads in their own way. As a member of the Iranian American community and being part of the Iranian American Bar Association, I think for us, fighting the ban has been really key, but also using this as a moment to push our communities to understand how this is tied to broader issues of immigrant rights, right? And how this is tied to broader issues around dealing with racial profiling, and pushing our communities in that way has been really important. Having impacted communities that have otherwise been insulated, and again, I'm only speaking for myself, really step up and show solidarity, support sanctuary city issues, support issues relating to ICE and targeting is really critical. That being said, you know, we also, many of us come from countries that are actively being bombed or facing sanctions or other pieces. And so I think this piece of what impacted communities should do is a complicated one, and supporting the leadership from within is really key. To your second point on the lawyer front, I would say just, you know, continue to be engaged. The ban is not over. People still need representation on their waiver cases. And so there's a lot of different opportunities to get plugged in that respect. And there's a lot of opportunities to take on cases and support, providing legal support for cases involving immigration detention and asylum and those pieces. And to me, these are all tied together, again, as broader attacks on immigrants and communities of color. So continuing that advocacy and continuing to give emergency legal support where it's needed is really key, while keeping the longer term strategies in mind.
Wonderful. And Elica, we do have a request from one of our audience members for practice pointers or resources that may be for attorneys who are representing individuals applying for waivers. If you do share that with us, we'll be sure to distribute it with the video recording that will be disseminated to all program registrants. And so they'll have that ready as well. So thank you for that. Khaled, any concluding thoughts for us?
Yeah, a couple of quick points. So I highly recommend a book from Professor Shobha Wadia called Banned. I think Elica mentioned earlier about the Penn State Law School's really important work and their clinic's work in direct services. So that book is excellent. It just came out 4 or 5 months ago. Highly recommend it. Second, I think that one thing I'd recommend, and one thing that was sort of disappointing to me during the height of the Muslim ban activism, was we saw a lot of the resources from communities being donated to large organizations, national organizations, while local Muslim organizations weren't receiving any kind of support or funding. So one recommendation I'd make moving ahead is for impacted communities to support their own local organizations, because those local organizations are the ones that provide direct services to the more micro immigration questions. And they're oftentimes working on very shoestring budgets. Another individual that did tremendous work is Abid Ayoub of the American Arab Anti-Discrimination Committee, who worked really closely with these local organizations. And third, most importantly, because surveillance is still an issue, less an issue now because mosques are closed down, but when this pandemic wears away, hopefully, God willing, in the near future, is for individuals on the community, on the ground, on the grassroots level, to be very vigilant and mindful of not speaking to FBI agents and individuals they suspect of being informants, because again, that ties really closely to the way the travel ban is used within communities and can lead to removals, deportations, and even arrests. So to be vigilant on that front is really key.
Wonderful. So thank you so much. We want to take this moment to actually thank our esteemed panelists. Thank you for making the time to join us for this webinar. As I mentioned, this is the last event lecture of our 6-part national lecture series. It's been a pleasure hosting and moderating these sessions. Please be on the lookout for the forthcoming Human Rights magazine from the American Bar Association, which will be dedicated exclusively to the issue of immigration and immigration law. It includes articles from Representative Chu, as well as from Penn State Law's Immigration Clinic, and a number of other authors that you will recognize. In addition, we have a forthcoming symposium from NYU School of Law that is going to feature the transcripts and other articles from panelists from this lecture series, and you'll receive additional details regarding that shortly. So thank you so much, stay safe, and we wish you well. Thank you.